Hello, I am Professor V. Keshav Rao, Professor of Law, National Law University, Odisha, Cuttack. I am making a presentation on this lesson titled Economic Analysis of Law. Economic analysis of law is a concept conceived by a jurist by name Richard Posner, and it was developed by him. As we all know, economics is a science of wealth. It deals with production of wealth, that is, the most important factors that contribute for production of wealth. Besides production of wealth, it also deals with proper distribution of wealth. The ultimate goal of economics is to ensure that there is proper distribution of justice. Hence, its chief objective is maximization of wealth in any given society. Therefore, the chief objective of economics is the maximization of wealth. It promotes maximization of wealth. On the other hand, justice, namely which is the chief objective of jurisprudence, is described as the science of law. It is concerned with production of good laws, the laws that command respect in the society, the laws that subserve the ends of society, and it also deals with proper mechanism of enforcement. Enforcement is a key factor in law. Therefore, proper enforcement of law is also part of the system of jurisprudence, and therefore, jurisprudence as a subject aims at maximizing justice. It promotes maximization of justice. Economics deals with welfare of man. Similarly, jurisprudence also deals with economics of man. Both deal with the welfare of human being in any given society. The basis of economics is that every rational human being always chooses to do what will maximize his or her satisfaction. If I want something badly, I don't mind to pay any price for it. This is the simple basis for the economics. The economic reaction of human beings in different kinds of transactions. If a rational human being wants something badly, then they will pay for it. If I badly need something, I don't mind to go to an extent and pay any price for the purpose of getting it. This is the basis of economics, and this is used as the platform for concept development of the concept called economic analysis of law. It is the modern form of utilitarianism. Economic analysis of law, like economics, treats with three different aspects. First important thing, utility. Second important factor, optimacy, that is what is the best for any transaction. And most important, efficiency, how best the result can be achieved by spending little. Low cost is its aim. How we can achieve the best in the society through law by ensuring that there is cost efficiency is the concern and the proper ambit of economic analysis of law. With this object, lot of exploration was made into jurisprudence. From the perspective of economic analysis of law, it opened new vistas for growth. Economic analysis of law has certain salient features. The first and foremost important salient feature is explanatory power. It explains the cost and effective exploration. It explores the cost and effect relationship, cost and efficiency relationship, and it explains how the cost can be minimized so that the effect can be the best efficient outcome. It also provides the empirical support, because economic analysis of law virtually involves investigation into what is practically happening in the society, and it has, most important, the object of value, that is as outcome. Efficiency of value as the outcome is the purpose of economic analysis of law. It explores and inquires into the means of maintaining goals. Are they efficient or are they inefficient? What are the objectives of law? What is the end of law? What are the goals of law? How they can be achieved? Are the means being adopted for their attainment, their achievement, efficient or inefficient? If it is to be found to be inefficient, then use of different methods for lower cost can be shown. That is the purpose of economic analysis of law. What is the cost and efficiency relationship? If the cost is more, what means have to be adopted for lessening the cost and attaining the ultimate objective of law is the reason behind the entire economic analysis of law. These are the important salient features. Now let us consider the genesis of and the evolution of the economic analysis of law. Economic analysis of law as it is known today is not a new concept. It was in vogue even until 1960s, but not with that nomenclature. Before 1960s, the economic analysis was mostly concentrating on business practices that were leading to monopoly. Especially, the economists were occupied with antitrust and monopolistic business practices. They were looking at those commercial practices which were resulting in antitrust and monopoly, and how the system ought to be to ensure that there is a proper distribution of wealth and the wealth is not concentrating in a few individuals. Their studies undoubtedly had a bearing on legal policy. The legal policy until 1960s was also determined in certain key areas of law on the economic policy. The economic studies have laid down the foundation for legal policy, especially in matters relating to antitrust and monopoly. This was a limited field of activity of economic analysis or the economists who are concerned with law before 1960s. But after 1960s, there is a virtual change in the very approach of economic analysis of law. No field was left untouched by it. And after 1960s, there is greater application of economics to the legal system. Starting from the foundations of the legal system in general and going to the specifics of the specific areas of law like tort, contract, crime, property, etc., economists started investigating the basis of law, the efficacy of the law, and the cost that is involved in ensuring the efficacy and efficiency of law, and are suggesting means as to how the end result of that particular branch of law can be achieved. It was actually pioneered by a great economist by name Guido Calabresi. He wrote an article on the title Thoughts on Risk Distribution in Torts. That is the first ever article which interpolated economic thought into the law of torts, which has now become the starting point of economic analysis of law. Afterwards, it was contributed by, fostered by, promoted by another economist by name Ronald Coase, who came out with what is known as in economic parlance Coase theorem. This Coase theory or Coase theorem is dealing with social cost, and these two are the pioneers, and basing upon the contribution made by these two pioneers, the economic analysis of law was seized by Richard Posner, and he started explaining how the economic analysis of law can be utilized for the legal system and can be made the basis for analyzing the efficacy as well as the efficiency of law, so that the value of law can be undoubtedly achieved. Let us now consider Ronald Coase's contribution. He laid down the framework for analyzing the assignment of property rights and liabilities in economic terms. In economic terms, why a person should be given a right, how a corresponding liability has to be imposed, how this right and liability dichotomy can be maintained so that the economic value of efficiency can be achieved is the framework he laid down. Basing on the framework, the field of legal doctrine was opened for fruitful economic analysis, and thus came into being a new nomenclature called a new approach to the study of law, a new approach to the analysis of law called economic analysis of law. Many doctrines and institutions of legal system which are prevalent today are best understood as efforts to promote efficient allocation of resources. How legal principles can be utilized to ensure efficient allocation of legal resources and natural resources. In fact, efficient allocation of all resources can be ensured is the purpose of this economic analysis of law, and therefore virtually every field of law has been made the subject of economic analysis of law. Now let us see the role of economic analysis of law. Basically, economic analysis of law plays two important roles. One, it can be described as a positive role. Second, it can be described as a normative role. In the positive role, the economic analysis of law only attempts to explain the implications of legal rules as it stands today. It takes a legal principle as it is obtaining in the society and makes an analysis of its implications. It only points out that these are the implications, whether they are beneficial to the society, good for the welfare of humankind or not. It never tries to change them. Changing them is not the objective of economic analysis of law, especially its positive role. It positively investigates the legal principle on the parameters of cost, utility and efficiency, and then points out which can be utilized and what is the efficacy of the current principles of law. Well, on the other hand, we have the normative principle of law, normative economic analysis of law. This normative economic analysis establishes that it would be inefficient to apply a legal principle. After positively establishing that these are the implications of any legal principle, the normative rule points out that it is better to apply a different principle, because it points out the application of the current principle of law will result in inefficiency, and the only way to ensure efficiency is by changing that operative rule. Wherever there is a value conflict, this is the third important significant role that is played by economic analysis of law. Wherever there is a value conflict, what is the preference to be adopted case by case is analyzed by the economic analysis of law. Let us take, for example, the policy of legalization of prostitution. Now, the conflict is morality versus materiality. If morality is adhered to, what is the cost that is being incurred by the society, by the legal system, and if materiality is to be encouraged, then what is the social outcome, what is best for the society, what is best for the people? Well, all this is actually studied. In case of this value conflict, which is the value to be preferred in economic terms is laid down by the economic analysis of law. Therefore, it has a positive role, it has a normative role, and most important, it also plays a very important role in conflict resolution, in the sense preference of the conflict of values. Which value has to be preferred when there is a direct conflict between two values? This is the main role to be played by the economic analysis of law in the current materialistic society. Now, coming to its application, it was said, I quote, "Judges frequently decide cases by choosing an outcome which will maximize the wealth of society. They are very clearly telling judges frequently decide cases by choosing an outcome which will maximize the wealth of society. And it is continued further that judges, especially the common law judges, have mostly unconsciously been guided by these economic considerations. They are guided by these economic considerations. The economic considerations of value, cost, efficacy and efficiency have been guided, and the guiding factors of the judges, either consciously or unconsciously, either openly or unwittingly, the judges have been influenced by these considerations in the maximization of wealth, because maximization of wealth will ensure that there is welfare in the society. Well, with such propositions as the launching pad, that judges invariably, inherently choose that which is economically the best for the society, Richard Posner attempted to demonstrate its use, the use of economic analysis of law in common law. He actually pointed out that common law is best understood by economic analysis of law, because the common law is subserving the welfare of the human beings and maximization of wealth in the society. Economic analysis and common law. Because Richard Posner's main focus was on common law, it is imperative that we consider the economic analysis and common law. In fact, he observed the common law method is to allocate responsibilities between people engaged in interacting activities. Whenever a contract takes place, there is interaction between two individuals. Whenever tort happens, there is an interaction between two individuals. In fact, law presupposes interaction between two individuals, and the economic analysis of law is to point out that the interaction must be in which way, whether it is maximizing the joint value. If it is not maximizing the joint value of the two persons involved in the transaction, be it tort or crime or contract, then what amounts to the same thing, which is in a different way minimizing the joint cost of activities. How to minimize the joint cost of activities when we cannot maximize the joint value of the activities? This precisely is the objective of economic analysis of law, and he says the common law method chooses either of these two methods. Number one, allocate the responsibilities between parties in such a way that either it maximizes the joint value or it minimizes the joint cost. How it proposes to do? There are basically three important approaches adopted by the common law according to Richard Posner. Number one, by redefining a property right, by conferring a property right on someone who doesn't have, or by divesting a person from a property right of a person who already possesses that right. The second important is devising a new rule of liability. For example, in case of environmental law, we come across a new rule of liability called polluter pays principle, or PPP. Now, this is a new rule of liability which was invented by law to meet the exigency of interaction between two individuals, resulting in environmental pollution, resulting in economic damages and damage to the society. And then the third important method is recognizing a contractual right, when new rights are to be conferred upon individuals who are entering into a contract, thereby ensuring that there is minimization of joint cost or maximization of joint wealth. Definitely the common law did not hesitate to invent and confer new contractual rights. Thus, redefining a property right or devising new rule of liability or recognizing a contractual right are the three important methods that were adopted by common law system for the purpose of ensuring that there is maximization of wealth or minimization of cost for both parties involved in the transaction, whatever may be the nature of the transaction in any society, especially in those societies which adopt the common law system. Let me provide to you an example of the economic analysis of law, how it peruses the entire transaction. For this transaction, let us assume that there are two persons, one a factory and two residents. The factory, let us imagine, emits smoke, causing damage to the clothes hung outside by 5 nearby residents. Therefore, in our transaction, on the one side there is a factory emitting smoke, on the other side there are 5 residents who hang their clothes outside, and because of the smoke that is emitted by the factory, the clothes are unfortunately being damaged. Now, let us imagine further that each resident suffers a damage to the tune of rupees 1000 per resident. Therefore, the total damage is rupees 5000. In economic terms, in monetary terms, the total damage that is caused by the factory to the 5 residents who are suffering due to the emission of smoke by the factory is rupees 5000. Now, what is the alternative for this? What has to be done? Now, there are two important avenues open for the factory. Number one, the smoke damage may be prevented by installing a smoke screen. The damage that is being caused by the emission of smoke from the factory can be prevented by installing a smoke screen on the chimney of the factory, but this would cost rupees 3000. Or the second important alternative remedy that is available is to purchase dryers and give to the 5 residents. That would eliminate the damage that is the result of the emission of the smoke by the factory. Let us imagine that each dryer costs 800 rupees, and because there are 5 residents, 5 dryers are required and a total of 4000 has to be spent. So, the two alternatives, one alternative calls for spending 3000 rupees, another alternative calls for spending 4000 rupees, and the actual damage is 5000 rupees. What is the efficient outcome in such a human interaction? In such a transaction that is taking place between two persons in a given system of law? This depends upon the legal principle. The outcome depends upon the light of the law or the rule of the law. Let us discuss the outcome in the light of the law. Let us assume that there is a principle which says residents are conferred with clean air. If residents are conferred with clean air, there is a corresponding duty laid on the factory that it cannot emit smoke which is likely to pollute the clean air. Therefore, there is a right conferred upon the 5 residents and there is a duty imposed upon the factory. Now, the factory has violated the duty, therefore, the factory is answerable. And what are the 3 alternatives available with the factory? Number 1, it can pay off the damages to the tune of 5000 rupees. Number 2, it can purchase by spending 3000 rupees a smoke screen and install it on the chimney. Number 3, it can purchase 5 dryers and give it to the 5 residents who are being affected by the smoke emitted by the factory. Out of these 3, which involves spending 5000, 3000 and 4000, well, naturally the factory owner that violated the provision of law would prefer that choice, that alternative which is of least expensive to him, namely he would go for the efficient solution, that is opting for installing a smoke screen and spending only 3000 rupees instead of 5000 or 4000. Now, let us see in a different way the same illustration. Let us assume the rule is there is no duty there is no duty or prohibition on the factory not to pollute. In other words, there is no corresponding right to free air or clean air conferred upon the residents. Now, if this happens, what is the solution left for the residents, because the residents have no cause for complaint? Now, they cannot claim the 5,000 rupees as damages from the factory, and the factory is not duty bound to spend 3,000 rupees and install the smoke screen on the chimney, and therefore, they are left with one alternative, that is by spending 4,000 rupees from their own pockets and purchase the 5 dryers, which will offset them from the damage caused by the factory. Or the other alternative is they have to spend 3,000 rupees and see that the factory owner is convinced to install the chimney, on the chimney, the smoke screen. I am sure that efficient outcome will be in the minds of the residents is to spend the 3,000, because they can't expect a damage of 5,000 rupees, and they are not willing to spend 4,000, because when the damage can be mitigated and stopped by spending 3,000 rupees, it is unwise to spend 4,000 rupees. That is a rational human being's thinking. Basing on this, the outcome would be that they would also prefer to pull up their own resource, earn or invest 3,000 rupees, purchase a smoke screen and give it to the factory for installing it. In other words, this analysis points out that irrespective of the choice of law, irrespective of the option available at law, a rational human being would always prefer that solution which is cost efficient. And here the cost efficiency lies in the option of smoke screen, not the option of dryers, or not the option of paying the entire 5,000 rupees by adopting the polluter pays principle. Now, when the cost factors are the same, this solution works very well. But when the cost factors vary, then the solution is not simple. This is one important limitation we must recognize in the application of economics law, in the application of economic analysis of law. Now, this economic analysis of law, which started on a broad base, has now narrowed down to specific areas. In fact, every area of law is virtually embraced and can be approached from economic analysis perspective. The theory of legislation is undoubtedly approached, because the fundamental belief of economic analysis is law that ensures greatest good to the greatest number of people commands respect. Whether a legal principle that is proposed to be enacted would ensure greatest good for the greatest people or not can definitely be assessed from the economic standpoint. Similarly, law enforcement. It is preposterous on my part to point out, because it is a common knowledge, that we always want an enforcement mechanism that is cheap, hassle-free and participative. This can be ensured not by the regular adjudicatory process, but by a simplified process. Therefore, Consumer Protection Act envisages and adopts such procedure, because it is economically more viable to a common consumer, an ordinary consumer, in preference to insisting that he must pursue the litigation in a normal court of law. The judicial administration can be on the same lines considered, because appointment of more judges, would it result in lessening of cases? Would it result in lessening of the cases that are pending before the courts? Or should we encourage the arbitration, mediation and conciliation as the alternative dispute resolution mechanisms? Well, this also can definitely be approached from an economist standpoint. Similarly, most important thing is the environmental regulation, because environmental pollution can definitely be assessed in terms of economy, and what kind of law would ensure that there is minimum damage to the environment, because what we require is a sustainable development. Similarly, theory and practice of punishment are not an exception, And civil law subjects like property, contract, tort are subjected to economic analysis, and criminal law and other branches of law are also being assessed. In fact, sexual harassment at workplace, what is the cost effect? What is the duty of the employer? Suppose a software company, there are female employees employed and who leave, let us say, at midnight. Now, there is every possibility of they being subjected to, as we are seeing today and hearing in radio and TV and also reading in papers, that they are being subjected to some crimes. Can that be avoided by imposing a responsibility on the employer? Because employer is using the services of the employees till midnight, can't we impose a duty? This requires a little bit of cost analysis, and that is undertaken by this cost economic analysis of law. Therefore, virtually there is no branch that is left out. Any branch of human activity in this materialistic world can definitely be subjected to economic analysis. This is the basis of entire economic analysis of law. Now, let us see the economic analysis of litigation. Economic analysis of the litigation involves, first of all, to make an assessment of the cost of litigation in the current adjudicatory mechanism and what is the cost of non-litigation. For the purpose of recovering 500 rupees, if I have to spend 5,000 rupees without guarantee that I am going to get a remedy in my favor within reasonable time, I am sure a rational human being doesn't mind to forego the 500 rupees rather than spending the 5,000 rupees. Thus, the analysis of cost of litigation versus cost of non-litigation would decide the matter of whether to go to court or not. This is as far as litigation. But once we go to court, there is an adjudicatory outcome. Without going to the court, if we involve in negotiation, there is an outcome out of the negotiation process. Should we go for the adjudicatory outcome or the negotiatory outcome? This decides whether to go for negotiation or not. Similarly, what is the cost of pursuit of litigation and what is the time and result of pursuit of litigation? Is it worthwhile? Is it cost effective? Are the factors which are undoubtedly being inquired into by the economic analysis on the broad basis of litigation as such, in the broad area of litigation per se. Now, let us go to the specific areas, especially economic analysis of tort. We all know that compensation is paid for accidents. What is the cost that has to be incurred for avoiding the accident? And if the accident cannot be avoided, what is the cost of prevention? That is, if prevention cannot be possible, cost of consequences. This is undoubtedly an important area of economic analysis. Actually, the economic analysis started with this kind of approach. Then similarly, we can go to the product liability. What is the cost involved in making the products more safe? And if accident occurs, what are the costs of accidents? If we weigh both of them, then we will be knowing which is the efficient method. Similarly, suppose a person involves in a rescuing act, then what is the liability he is likely to incur and is he likely to get any restitution? The dichotomy between the liability and restitution would undoubtedly pave way for understanding the law of torts as far as the rescuer and his claim for compensation because he tried to interfere for the benefit of somebody can be looked into. On similar lines, we can also take up economic analysis of contract. For example, a contract is entered into for the purpose of building a block or a house. The estimated cost for building the house, let us say, is 50 lakhs. The contract is agreed and the builder agreed to build it for 50 lakhs. After the agreement is entered into, before the performance is due, there is lot of increase in the building material cost, either because there was heavy demand or because of certain other factors there is heavy demand, and with that cost the completion of the building requires an investment of not less than 70 lakhs. If the builder is going to invest 70 lakhs and the owner has to pay only 50 lakhs, there is a clear cut danger of suffering loss to the tune of 20 lakhs. And let us say the agreement also provides for liquidated damages. The contract clearly states whichever party has violated the promise made, the responsibility undertaken or the obligation undertaken has to pay 5 lakh rupees as damages to the other party. Therefore, the effective remedy is not by spending 20 lakhs, but by simply adjusting oneself to the tune of suffering only to the extent of 5 lakhs, and therefore, there would be a decision to commit breach of contract than to perform the contract. Therefore, most of the commercial contracts will have an escalation clause. The escalation clause, how far it is effective, when it is going to offset the differences in costs compared on the date of agreement with the date of performance, is definitely an important area which can undoubtedly be considered. Which is better for me is the thinking of contracting party, because every contracting party, being a rational human being, he would like to see which is beneficial to him. Similarly, let us look at economic analysis of crime. Well, what is the cost of keeping an accused person in jail before the trial? What is the cost of the prosecution and trial? What is the cost of keeping the convicted in jail during the term of conviction? On the other hand, what is the cost of dropping the trial, and what is its impact on the society? Well, this is also being subjected to economic analysis, some economists. But we should not forget that there are certain values in the society and certain societal implications on dropping out the prosecution altogether or declaring that the act is not a crime at all. Similarly, plea bargaining also carries certain implications. Well, these implications are also subjected to the economic analysis of law. In spite of its widespread application, in spite of several economists as well as law scholars undertaking the economic analysis of the law in general and specific areas of law in particular, the economic analysis of law was not over criticism. It is not above criticism. In fact, it was subjected to bitter criticism. The first important criticism advanced was it ignores justice. They argue that efficiency becomes a means of rationalizing and sustaining economic inequality. When we find in this society economic inequality and we are following the policy of distributive justice, then economic analysis of law, which is contrary to the distributive justice philosophy, well, it ignores totally the concept of justice. Then the second important criticism is it manifests a conservative political bias because it advocates free market system. In free market system, everyone is capable of taking care of his own interests. Therefore, there must be absolute free interplay permitted between the parties is the basis. And most important criticism is that the economic analysis is repulsive of fundamental social norms. One of the important fundamental social norm is that a person who committed the crime must be punished, and plea bargaining, which promotes purchasing of justice, which is alleged to encourage the rich people to commit accidents and then escape punishment by entering into plea bargaining. It is repulsive to social norms, is the third important criticism. Then basically some question, is wealth a value? And they argue that increasing social wealth does not automatically guarantee that the society becomes better. Some individuals may become better, but the society as a whole may not become better is the point they make out. And why efficiency? Why not effectiveness? Some argue that effectiveness is a more important value than efficiency. And ultimately they say logic of law is not economics. Logic of law is reason, and the purpose of law is not maximization of wealth, but the purpose of law is maximization of justice. Therefore, there are antagonists against this economic analysis of law. Let us have a look at the way forward. As a postgraduate student of law, all of us should remember that legal education primarily consists of teaching students to dig beneath the rhetorical surface to find the true grounds of legal decision. Economic analysis of law also makes a foray into the true grounds of legal decision, and the economists who did this analysis pointed out that the judges were mostly influenced by the economic considerations and maximization of wealth. Though they do not explicitly state these grounds, they are undoubtedly influenced by that, and many of which turn out to have an economic character. They argue many of the legal decisions turn out to possess that economic character, and the study of this is definitely a useful tool in understanding the necessity of legislation, the efficacy of legislation, and the necessity of changing the law. The economic analysis of law undoubtedly opens up one's mind to treat the subject not heterogeneously but homogeneously, because there are different perspectives from which law can be looked into, and this is another important perspective, the economic perspective, titled the economic analysis of law. And lastly, may I emphasize that value, utility and efficiency are undoubtedly necessary in any given society. Besides justice, justice cannot be ignored as an important value. In fact, the value of value is justice. That is the science of law, the object of jurisprudence, and how economics, the discipline of economics, can subserve this ultimate goal is undoubtedly a welcome field of study, and economic analysis of law opens our mind to new vistas, and a proper understanding of jurisprudence and a proper estimate of the efficacy of law can undoubtedly be contributed by this new concept, that is economic analysis of law. Thank you.